Hello everyone, I'm Debojit Das and this is LiveLaw Daily. Today, August 24th, is Ukraine's Independence Day, marking the 1991 Declaration of Independence from the Soviet Union. Interestingly, just a year earlier, Ukraine's parliament had adopted the Declaration of State Sovereignty on July 16th of 1990. Which laid an important foundation for independence. The 1991 declaration was later endorsed in a nationwide referendum. And today, as Ukraine continues to navigate one of the most difficult periods in its modern history, August 24th remains a powerful symbol of its independence and sovereignty. And with that, let's look at the most important legal developments from India's courts today. For our first story today, the Supreme Court has put an interim restriction on construction and potentially polluting activities around the Jojari River in Rajasthan, citing serious ecological degradation. A bench of Justice Vikram Nath and Justice Sandeep Mehta has directed that no construction or development activity can take place within 100 meters of the edge of the river for now. This restriction will remain until a scientific exercise is completed to determine and demarcate the high flood line and the required ecological buffer zones. But there is another wider restriction, and that is where the flood line has already been identified, no industry or activity capable of causing pollution or contamination can operate within 500 meters on either side of it. Where the flood line has not been identified, the 500-meter restriction will apply on either side of the river's present flow path. The court is dealing with ecological degradation and industrial pollution affecting the wider Jojari-Bandi-Luni river system. It also looked at the functioning of two bodies involved in the restoration exercise, the High-Level Ecosystem Oversight Committee and the Integrated Coordination Group. Since their compositions substantially overlap, the court said that their respective roles need to be clearly delineated. The court has clarified that the Integrated Coordination Group is essentially an internal government arrangement and does not interfere with the committee's role. It has also empowered the committee's chairperson to issue directions wherever necessary for coordinated implementation of the court's orders. The matter will next be heard on September 22nd. For our second story, a journalist who was among the first to report allegations of theft and irregularities in Ram temple donations in Ayodhya has approached the Supreme Court for protection in a separate case registered against him in Ghaziabad. The journalist is Abhishek Upadhyay and his lawyer mentioned the matter before the Chief Justice of India, Suryakant, today. The Supreme Court has agreed to hear his plea tomorrow. So what is this case about? Upadhyay is challenging an FIR registered at Indirapuram police station on August 18th, arising from an alleged road rage incident near Shipra Mall. According to the complaint, a motorcycle was allegedly hit by a Baleno car. The complainant alleged that the driver abused and threatened him and named Upadhyay in connection with the car. But Upadhyay disputes this account. He says that while returning from his daughter's school, a motorcycle bondman approached his car and created a commotion. He denies any collision or physical confrontation, saying he left because his daughter was with him. He has also pointed to a discrepancy in the FIR. While it refers to a Splendor motorcycle, he says that the registration number mentioned belongs to another bike. Upadhyay further alleges that police personnel approached the shops near the spot of this incident and pressured the shopkeepers to delete or withhold CCTV footage, and has sought preservation of his electronic evidence. He also says that a team of around 12 police personnel visited his residence at night on August 20th, when he was away and his wife and two daughters were at home. His plea alleges that the FIR is false and connected to his investigative journalism. He has sought quashing of the FIR and protection from arrest and coercive action, and alternatively, an investigation by an agency other than the Uttar Pradesh police, including the CBI. The Supreme Court will hear the matter tomorrow. For our third story today, the Allahabad High Court has struck down key provisions of the Uttar Pradesh's 2021 tenancy law, holding that they conflict with existing parliamentary laws. A bench of the Allahabad High Court was hearing a batch of 16 petitions challenging the Uttar Pradesh Regulation of Urban Premises Tenancy Act of 2021. So what exactly has the court struck down? The court declared sections 8, 9 and 10 of the 2021 Act, which deals with rent revision and determination, as repugnant to the Transfer of Property Act of 1882. The court found that while the Transfer of Property Act governs rent according to the terms of the lease, the 2021 Act created additional mechanisms for increasing and determining rent through the Rent Authority. The court also found that the Act created a statutory grounds for eviction which could not be reconciled with Section 111 of the Transfer of Property Act, which lays down how a lease is determined. There was another issue, and that was the dispute resolution mechanism. The court declared sections 38 and 42 illegal to the extent that they sought to override the procedure under the Provincial Small Causes Court Act of 1887, read with the Uttar Pradesh Civil Laws Amendment Act without presidential assent. Importantly, the court has not struck down the entire 2021 Act. Applying the doctrine of severability, it struck down only the provisions found to be in conflict with law. And what happens now? The court said that there would be no legal vacuum. The earlier Uttar Pradesh Urban Buildings Regulation of Letting, Rent and Eviction Act of 1972, which had been repealed by the 2021 Act, will spring back into operation to the extent required. The court has also protected concluded matters where the validity of the 2021 provisions had not been challenged, while quashing the individual orders challenged in these 16 petitions. So this is not the end of the Uttar Pradesh's tenancy regime, but several key provisions of the 2021 law are no longer enforceable from today. For our fourth story today, TMC Member of Parliament Mahua Moitra has approached the Supreme Court over an eviction order involving a circuit house in Nadia, West Bengal. But the court was not immediately willing to entertain the plea. Mahua Moitra has challenged an order directing her to vacate the circuit house where she usually stays during visits to her constituency. Her lawyer told the Chief Justice of India Suryakant that the local administration had issued the order late at night despite a Calcutta High Court direction granting her protection. He sought an earlier listing, saying that the matter raised questions of federalism and required an independent investigation. The Chief Justice of India, however, responded, "Please keep it to yourself. We are not going to entertain." Mahua Moitra had earlier described what had happened on August 14th. She said she entered the circuit house at 6:30 p.m., was served dinner at 9:20 p.m., and received a call at 9:47 p.m. asking her to leave. The district collector's order was then sent to her at around 10:50 p.m. She also alleged that a crowd had gathered outside chanting Jai Shri Ram. Moitra later said that she refused to vacate, writing that she was not backing down. And there is a recent Supreme Court connection here. Earlier this month, when Mahua Moitra had sought permission to appear virtually before police because of apprehensions of mob intimidation, the court refused, with Justice Dipankar Datta asking why, having entered politics, she feared eggs being thrown at her and referring to freedom fighters taking bullets. The latest plea has now been brought before the Supreme Court, but the court has so far expressed reluctance to entertain it. For our next story, the Supreme Court will consider whether former High Court judges can be co-opted as women members of the state bar councils without running into a constitutional restriction. The issue came up before a bench led by Chief Justice of India Suryakant, and after senior advocate Sanjay Parekh, appearing for 6 state bar councils, raised an objection to the inclusion of former High Court judges. Parekh pointed to Article 220 of the Constitution, which restricts a retired High Court judge from practicing in the High Court where they had served. His question was whether that restriction could also create a problem if such a judge is made a member of the Bar Council. He also questioned whether the Supreme Court could use Article 142 to pass such a direction contrary to the Advocates Act. The Chief Justice of India explained that the court had issued the earlier direction because there were repeated applications and uncertainty over how the co-option process should work. Every day there was a new application, a new mentioning, the Chief Justice of India said, adding that the objective was to ensure women's representation in state bar councils. But on the Article 220 issue, the court was open to examining the question. The Chief Justice of India said, "You have pointed out something new, which may be an impediment in constituting the councils. We will examine." So why does this matter? The Supreme Court had mandated 30% women's reservation in state bar councils while permitting 10% of the seats to be filled through co-option where enough eligible women candidates may not be available. On 4th August, the court had allowed the High Court Chief Justices to co-opt women members from among former High Court judges or advocates. For now, the court has said that it will not alter that direction, but the Article 220 question remains open for consideration if it is referred to the court. For our next story, the Bar Council of India Chairman Manan Kumar Mishra is now receiving support from the Karnataka State Bar Council, which has expressed complete solidarity with him amid the ongoing controversy. The Karnataka State Bar Council has strongly rejected allegations made against Mishra by Bar Council of India co-chairman and senior advocate Y.R. Sadashiva Reddy. In a statement, the council described Reddy's August 22nd letter as politically motivated and baseless, alleging that it was aimed at creating artificial friction within the legal fraternity. But the Karnataka Bar Council also questioned Reddy's own record. Its chairman V.D. Kamareddy pointed out that Reddy had served as a Bar Council of India chairman and co-chairman for nearly a decade and had participated in the council's administrative, financial and regulatory decisions during that period. So the council's question was, why are these grievances being raised only now? The Karnataka State Bar Council called the allegations opportunistic and questioned their good faith. It also said that Reddy had been removed as the Karnataka Bar Council's BCI representative by a 2/3 majority, citing his inefficiency and unsatisfactory performance. The council added that Reddy continued in the BCI post afterwards with Manan Kumar Mishra's support. The Karnataka State Bar Council further noted that Reddy did not contest the recent State Bar Council elections and is no longer an elected member. At the same time, the council praised Manan Kumar Mishra's leadership, citing steps relating to advocate welfare, digital infrastructure, and institutional functioning. It has now appealed to lawyers across India to remain united under Manan Kumar Mishra's leadership and reject what it described as politically motivated distractions. So, as the controversy continues to unfold, the Karnataka State Bar Council has now firmly put itself behind the BCI chairman. For our next story, social media platform X or Twitter has told the Delhi High Court that posts allegedly revealing journalist Saurav Das's residential addresses have been taken down. The submission came in Saurav Das's lawsuit against commentator Abhishek Mitra and several web portals over allegations that his residential address and other personal information were disclosed online. Justice Sachin Datta issued summons in the suit and notice on Saurav Das's application seeking interim relief. Appearing for Saurav Das, senior advocate Akhil Sibal alleged that personnel of news portal The Pamphlet had entered Saurav Das's residential property without consent and recorded a video, which was then later added to by Abhijit Mitra. Counsel for The Pamphlet said that the posts on Twitter were no longer accessible because the platform had taken them down, while seeking a time to file a response on the merits. Sibal meanwhile urged that the post specifically identifying Das's address should not be restored. Twitter's counsel confirmed that the links were no longer accessible and the court recorded the submission. Saurav Das has alleged that his precise residential address, details about his family and other sensitive personal information were repeatedly published and amplified online. He says that this has created a continuing apprehension about his safety, particularly because he claims to have previously faced threats and targeted hostility. The suit seeks permanent and mandatory injunctions as well as damages, alleging violations of his privacy, dignity, and security. The court has also allowed Das to correct the name of one of the defendants in the plaint. For now, the disputed X or Twitter posts are down, but the underlying privacy and safety issues will continue before the Delhi High Court. For our next story today, the Supreme Court has issued notice to the Jharkhand government and the Jharkhand Public Service Commission over allegations of malpractice in the Jharkhand Combined Civil Services Preliminary Examination. A bench of Chief Justice of India Surikant, Justice Joy Malia Bagchi, and Justice V. Mohana was hearing a petition filed by activist Harisharan Devgan seeking an independent and time-bound CBI investigation. Senior advocate Manan Kumar Mishra, appearing for the petitioner, told the court that students had been protesting for over a month over alleged irregularities in the examination. The state had cancelled the examination, But the Jharkhand High Court stayed that decision. Manan Kumar Mishra argued that the investigation should now be transferred to the CBI or alternatively be handled by a retired Supreme Court judge. The Chief Justice of India, however, clarified that a former judge cannot be asked to conduct an investigation. The bench also asked whether judicial recruitment examinations in Jharkhand are conducted by the State Public Service Commission. Manan Kumar Mishra replied that they are. The petition says that cancelling the examination alone does not address the allegations of systematic corruption and seeks an independent probe into the role of public officials and examination agencies. It also asks that crucial evidence be secured, including original and candidate-held OMR carbon copies, CCTV footage, and server audit logs to prevent any possibility of tampering. The Supreme Court has now sought responses from the state and the Jharkhand Public Service Commission, while the demand for an independent probe remains before the court. For our final story today, the brother of Sohrabuddin Sheikh has now approached the Supreme Court challenging the Bombay High Court's acquittal of 22 accused in the 2005 encounter case involving Sohrabuddin, his wife Kausar B, and his aide Tulsiram Prajapati. The petition has been filed by Nayamuddin Sheikh, Sohrabuddin's younger brother, against the Bombay High Court judgment delivered by a bench of Chief Justice Shri Chandrasekhar and Justice Gautam Ankhad. The case dates back to 2005, when, according to the prosecution, Sohrabuddin and Kausar B were abducted while travelling by bus from Hyderabad towards Maharashtra. Sohrabuddin was subsequently killed in an alleged encounter near Ahmedabad. Kausar B was killed 3 days later, and their associate Tulsiram Prajapati was killed in another encounter in 2006. The Supreme Court had earlier transferred the investigation from the Gujarat CID to the CBI and shifted the trial from Gujarat to Mumbai. The special CBI court acquitted all 22 accused in 2018, and the Bombay High Court recently upheld that acquittal. The High Court noted that 92 of the 210 prosecution witnesses had turned hostile, but said that this by itself did not establish that the trial had been improperly conducted. It also found that the prosecution had failed to establish the alleged abduction, the motive for a fake encounter, or a political police nexus. The High Court described the prosecution case as one based on circumstantial evidence with several broken links in the chain of circumstances. Nayabuddin has now challenged that finding before the Supreme Court. The petition was filed on August 13th, and the matter is now before the Apex Court. That's all for today's most important updates from India's courts. As always, you will find the link to each story in the description box below. And for more developments and detailed reports, subscribe to LiveLaw and visit livelaw.in. We'll be back tomorrow with another roundup. Until then, stay updated to everything that is law.